Right. Good evening, everyone. A warm welcome to today's live webinar brought to you by Legal Specs. Today, we're diving into a topic which every lawyer and business professional needs to master: contract lifecycle management. Contracts don't just end when they are signed. That's actually where the real journey begins. From drafting and negotiation to execution, storage, and archival. The way we manage contracts can make or break business efficiency and compliance. This webinar is designed to give you practical insights into how contracts evolve through their life cycle and why mastering contract lifecycle management is a critical skill in today's legal and business landscape. Before we begin, I have a few housekeeping instructions for the participants. Keep your microphones mute during the talk while ma'am is speaking. But there are quite a few Q&A sessions which we have curated, and at that time, I would request you to turn your mics on and turn your cameras on for that matter as well. The session is being recorded and will be available on YouTube later. Please turn on your cameras so that this session becomes an interactive one. During the session, if you have any question, drop them in the chat box at any time. We have a dedicated Q&A session after each segment, during which we will take up those questions, so you can unmute yourselves for that matter as well. Apart from that, a feedback form is also going to be shared after the session, which you have to fill if you would like a certificate of participation, and as well as the to improve our future events, that form would be helpful. So sit back, engage, and take notes. You're in for a very insightful session. In today's fast-paced corporate world, contracts are the backbone of every business relationship, but managing them effectively across creation, negotiation, execution, storage, and also archival is where the challenges often arise. CLM is more than just legal drafting. It's about ensuring transparency, compliance, efficiency, and accountability at every stage of a contract's journey. And who better to guide us through this than our expert speaker for today, Shria Tikoo. Let me introduce this powerhouse behind today's session. Ma'am Shria Tikoo serves as Assistant Vice President Legal at Kulfi Collective, which is a full-stack award-winning creative studio which builds brands in culture. She earned her BBA LLB degree from Symbiosis Pune and pursued an LLM in IP laws at Washington University, St. Louis. After a successful stint at a software company in the US, she returned to India and began her legal career with Universal Music Group, where she led negotiations and managed agreements for both label and publishing sides of the business. With over 6 years of experience in the media and entertainment industry, Shria now leads the in-house legal team at Kulfi Collective and manages documentation with high-profile clients, including Red Bull, Netflix, Spotify, Audible, Tinder, and Lego. She is passionate about leveraging her legal expertise to help businesses shape the future of content and tell stories that resonate with young Indians. When she isn't working, Shria enjoys consuming content across music shows, movies, and non-fiction books. Please join me in giving a warm virtual welcome to Shria. Shria, the floor is all yours. Thank you so much for joining us today.
Thank you, Preksha. That was a very long introduction. I know I've only helped you with the words, but when somebody else says it, it sounds like you're talking about a totally different person. Thank you. I am accepting the welcome with humility. All right. So let's start with trying to turn on our cameras if that's possible. Someone's raised their hand. Okay, all good. Okay, so for the first 2-3 minutes, we can unmute our mics. I want to understand what kind of crowd we have here today. So any of you who's still not graduated?
Yes, ma'am.
Yes, ma'am.
Yes, ma'am.
Yes, ma'am.
You can call me Shria,
Yes, ma'am.
and you can raise your hand or you can do an emoji blast or whatever you want.
Yes, ma'am.
Okay, so quite a few of those. All right, perfect. And how many of you are young graduates, less than a year or two of experience? All right. Okay, the ones who have graduated and they're working now, how many of you are in-house? Please put down your hands, everyone, and all the in-house people, yeah, either write in the chat or raise your hand. Great. Which means if I need suggestions, I might um, be able to get a few from the audience. So that's great. Last request, if you're able to switch on your cameras, that would be great. I would like to put faces to the names that I see here. However, if you're not comfortable with it, I'm totally okay. And yes, let's get started. So today's session, as you all know, is about contract lifecycle management. And these sound like really big words to non-legal colleagues of mine. And they're always like, what life cycle are we talking about? It's, they always think of it as standard documents being signed with only some commercial, details being moved around. But that's not the case. We all know that. If that were the case, we wouldn't be sitting here. AI would have taken over completely. And considering that's not happened yet, I guess it's not all template, it's not all standard. So let's discuss what CLM is all about. And I'm going to dive right into it. In a couple of slides, I will also give you an overview of the entire webinar so that you know what the structure is and where the question answers are. And then we can just do relevant questions for that section and then move on to the next, and you will know what flow you are in for. All right, just give me 1 second. All right, perfect. So, firstly, just meaning of contract lifecycle management. Start to end, birth to death, and maybe a little bit of afterlife also. Maybe rebirth as well. So that is contract lifecycle management right from the get-go of any kind of project, any kind of commercial understanding, wherever you need any kind of documentation, paperwork, an agreement signed between two parties. That's where it starts. And it ends at, of course, when you sign it. However, there could be a lot of post-signing obligations or things that you have to keep in mind. So that is also a part of the life cycle. And of course, renewals, which is why I said rebirth. So that is also a very important part of contract life cycle management. Now, there are two ways of doing anything. One is manual, one is automatic. When it comes to agreements also, the manual management is what you would do on whatever your company or your firm provides you with. So that could be any kind of written forms, any digital forms, your Google form, Google Docs, Google Sheets, Microsoft Word, Excel, whatever you have. And of course, then to save all the signed documents, you would save everything on your Google Drive or a shared local drive. So that's how manual management happens from a bird's eye view. Of course, a lot of details within it. The other side is automatic, which is basically not automatic, it's just automated. It's on a CLM platform. Usually these platforms are either templatized or they are AI powered in some way or form, or they basically have some way to make our lives more efficient. So again, nobody is taking your position, they are just making it efficient. Whatever manual work you would have to do, the CRM platform would probably take lesser time and do it with the same amount of accuracy or around the same amount of accuracy. Whenever you want to get a CRM platform to your company or your firm, generally, I think for law firms, it would be easier to get any sort of legal platforms on board because you are business development and you are not a cost center. But with other industries where you are just a legal team or a legal partner, it is a little difficult. So you should try to understand the kind of problems that you have, and instead of just having a fancy system, have a problem statement. Try to understand that there could be degrees of automation, there could be cost attached per person or per contract, and of course, if your organization as a whole isn't ready to accept something new. right? A lot of us are just very used to DocuSign and Adobe Sign, and we're all very comfortable with that. Or a lot of us are still signing everything physically. But it's very important to see what kind of an industry you're in. Now, I am with a media company, a lot of young people around, a lot of, irrespective of their age, they are very tech savvy because they deal with a lot of tech related creative outputs also. So it's easier for us to implement external solutions. However, if you were in a bigger company, a legacy company that dealt with paints or automobiles, it would probably be a little bit difficult for you to get people onto that platform, even though it would be a very efficient way of doing your contracts. But that's it, one shoe does not fit all. So starting with manual management, we'll then go into how a CLM would do it, like a CLM platform would do it. And this is the overview. So the manual management section will be taken up in 4 stages. So these are the 4 bigger sections of today's presentation. After each stage, we can stop and do Q&A. And of course, if we are running out of time, we can leave questions for towards the end of the session also. After we're done with the 4th stage of manual management, we'll move on to the CLM platform section, where I will do a quick run through because we would already have discussed stages 1 to 4. I will just help you with a comparison of what changes and how very quickly across all stages. And of course, there's a 5th stage for a CLM platform that they are able to give to us, which is analytics. So that is something that we will also discuss at the end. Everyone's with me till now?
Yes, ma'am.
Yes, ma'am.
Great. Okay, so any questions? Shelly, you've raised your hand. Do you have a question? Okay, that was probably my mistake. All right, moving to manual management. Here, this is my favorite stage. Yeah. Do you have a question, Hariom?
Yes, ma'am. And all the
Yeah.
things that you have, uh, all the things that you have talked about, those that, but ma'am, I want to know a simple meaning of contract lifestyle management. So, what is the real meaning of this, ma'am?
As I said, life cycle would be just start to end of anything, right? So contract life cycle management essentially means start to end and then restart of any kind of legal documentation or any kind of contract per se. So that would obviously entail a lot of steps, which would mean creation of it, negotiation, and then of course signing, storage, post storage, post signing. If there is any kind of obligations that you have to take care of, you have to monitor those. And then of course, once all of that is done, if the contract is expiring, do you want to renew it? Do you want to terminate it in the middle of the project or whatever the agreement between the parties is? So that is contract lifecycle management. That is what it is. How it can be done is something that we will be discussing now.
Yes, ma'am.
Are you satisfied with the answer?
Yes, ma'am. I'm satisfied.
All right, moving on. So let's discuss stage 1 fully, and then I'll be happy to take any questions for this section or otherwise also. Stage 1 is creation of a contract. Now, the first thing that you should always have is an agreement template. Any kind of deals that you are into, be it media related, in my case, be it an NDA, which is a non-disclosure agreement, mutual, unilateral, whatever it is, you need to have templates in place. Now, what are these templates and how do you make them? Nothing. These are just agreements that your company has been doing for a long time, or if you are a new legal person within the team or within the organization, then you need to start those templates, which basically you can get made from a law firm, or you can look up online, draft them on your own if you have been trained to do that during your internships. If not, then there's a lot of classes that you can attend. You can draft your own agreements. But these templates are basically documents that you will use. Yes, you will get the PPT. Sorry. So these are templates that you will keep using. And this is something that is the core of your business. So if you're into manufacturing, you will probably have sales agreement or procurement agreement from both sides of whoever is supplying things to you or whoever is purchasing things from you. Now it's in our case in media, when we are creating a film, for example, there could be the brand that we are making the film for, and then there could be our directors, DOPs, designers, animators, editors, all of these guys. So the number of agreements that we do on a regular basis, we should definitely have a templates for those agreements, and that is the very first step of being able to make a contract. The second step then is, after you have an agreement where you can put in information, to understand what this information is. Now, to get this kind of information, there are many ways. You can do Google Forms, or you can do Excel sheets, or you can, sit with somebody and try to understand. I have done almost all of these. You, depending on the complexity of the deals that your company handles or your team handles, you can devise a method and you can try to understand all the deal terms and put all of that information into the template. Now, again, one shoe does not fit all. I have worked in 2 different companies before this, and very different ways of procuring information. Here, because there are a lot of details, we have a full 2-page long document where there are so many details about each and every deliverable, from rights to, per asset fee and stuff like that. But when it comes to, for example, just making a song, it's straightforward. You're making me a song, you're giving me all rights. You can just sit and have that discussion, get all names correctly done on your notepad, or they can send you on MS Teams or Slack, whatever you work on, and you have your information. So many ways of getting this information. There is no correct or wrong way of doing it. Also, if your company already has been doing something, but you think it's not working, that it's worth a shot for you to request them to change the process a little, because if that helps with efficiency, why not? The third step, after getting the information, putting it in the templates that you already have, is to understand what accepted formats are for your industry or your company. And a lot of people that I know, a lot of companies that I know, work on MS Word. Most of them keep it open and not locked. But of course, any changes that are done have to be done in track mode. Quick raising hands of people who have used the red line feature or track changes feature on MS Word. I do not believe that out of 139 people, only 3 people have used this feature. But okay. So after MS Word, I see that a lot of people use Google Docs, because a lot of people do have Gmail IDs given to them by the company. Sorry. So after MS Word, we've got Google Docs that is widely used. Then we also have PDF that people use sometimes. A lot of times it's just to show that we won't be accepting any changes, but not a lot of times I've seen that. Just a second, Preksha, who has admin rights to the meeting?
Ma'am, I am the one who's doing it. Is there something?
Acha, because yeah, somebody has been muting the call for some reason. But anyway, if I see it again, I'll let you know. Thanks. Okay, so MS Word, I have also seen it locked sometimes. What it helps you with is that if you send me an MS Word document which is locked, any changes that I make will be redlined automatically, and you will not have to compare the previous draft to this one. You will already know what the changes were. It's basically a safeguard for you to be able to ensure that I'm not making any changes slyly without letting you know. But the problem with that is that if I receive the locked version, I will not be able to do a compare or combine changes feature on the MS Word platform. So that is definitely an issue. But apart from that, MS Word is the most widely used software for your agreements, and we should, I think, keep using it till we have a better platform with us where we can probably collaborate in a way where we don't have to delete anything without letting the other person know, etc. So basically something that's more convenient. But for now, MS Word is the most convenient, and that is what I also recommend. So on this stage one, which is creation, do you have any questions? Do you think I'm going slow or fast? Let me know, please. Okay, all good. So moving on, my favorite part of any agreement or project negotiation. Okay, I'll be slower than this and I'll try to explain a little bit better. Okay, so stage two is negotiation. After you have created a document, so let's do this between Preksha and me, okay? Preksha has created a document. She spoke with her business team. She got all the details in, and okay, let's assume I am a big brand, and Preksha wants to make a brand ad for me. So she's my production house or my agency. She has spoken with her creative teams and her commercial teams. She has all the details, and she's going to make me, I sell teacups, okay? Because I like tea a lot. So that is what I could think of. So she's now understood from her team that there is one main film that has to be made, and I will own all the rights or whatever. I will only use it in the digital medium. And that's what Preksha knows. Okay. And she has added all of those details into her template. And now she has sent it to me. Now, what I do is obviously review it. Now, a lot of us use the words review and redline interchangeably. Why it's not the same is because review is basically the act of going through something. Redline is how you do it. The review could just be, skimming through something or going through something or just reading it. Redlining is the actual act of the using that feature where you will be able to make changes or mark changes, and that's when the other party will get to know that, oh, they have made these changes, and that's how we can then move to the next stages. Now, Preksha has sent her draft to me. This is her first draft. I go through it. My pointers to go through the agreement or to review the contract would be, one, everything should obviously adhere to the law. So if I smuggle something, or I'm into drugs or whatever, something illegal, she shouldn't be working with me in the first place. Second thing, another example could be if she is asking me for an advance, but I'm not paying her. Now, that's not like against the law, but it's probably against the commercial understanding because usually advances are given. So that is the second point. Third is organization's policies, of course. Now, if Preksha has asked me for something really big or something unusual, and vice versa, then we'll have to tell the other side that, hey, so we are not able to do this because of XYZ reason. Now, of course, a lot of us end up saying things like, can't do this, company policy, global will not allow, etc., etc. If you're a very big player in the industry, or just like a big player in general, great, good for you. You will probably say that, and the other party will be like, okay, cool. But you shouldn't do that. Ideally, you should be able to explain your point to the other side instead of saying it's company policy. why is it company policy? Sometimes there are things that are not even adhering to law, and they lawyers cite it as company policy. Do not take it on face value. Ask them that question, ask them why, and try to understand what it means to have this as a company policy. Now, if Preksha has asked me for 90% advance money and 10% just before delivery, I will probably not work with her ever again, because I'll be like, listen, I can't give you all 100% of my money before you have delivered anything to me. So, simple transaction. Um, that could be an organizational policy, but Preksha, without any advances, working completely, delivering everything, and then I pay her after 60 days, and by law, I'm supposed to pay her within 45 days, shouldn't work for her also. She should say no. So these 3 points are generally what I think of while I am reviewing a contract. Now, very important, contract redlining. How do you want to do it? What kind of features do you use regularly? I was not going to do this, but let me open a draft and show you, if you've not done redlining before, how we can do it. Just give me a minute. Yes, here we are. Now, this is a simple location agreement that we usually sign with whoever we are shooting with. I mean, at the premises that we are shooting at. And yes, now if Preksha sent me this, a blank copy, what I would do, go here to review, switch on track changes, write the date. So today is 7th September 2025. Name of the owner or manager, I'm going to write my name here. Okay, so this is one feature that we always use. Okay, then another is comment. Now, very important to also know shortcuts. Without going here, I will just comment on this. And without clicking anything, I have also come out of the comment. Very important to know keyboard shortcuts also, because everything will just get faster and it will get easier, and it will be a wonderful journey, and you will not have to use your mouse so much. I know a lot of people heavily depend on their mouse, but when it comes to Excel, Word, there are a million keyboard shortcuts. There are many more features within these platforms, and we as lawyers should know MS Word inside out, at least the features that we absolutely have to use on a daily basis. Like when you're cleaning up a draft, you can just do delete all comments. If you're not cleaning up the draft for signature, but you are midway somewhere, but you are just done with how cluttered it looks, you can delete all the resolved comments, because you know you've had those conversations, it's done. So those are out. Here, when you're signing the document, again, all changes you can accept simply, and you can stop tracking. Why? Because sometimes you need to write the execution date towards the end. So you can just accept all changes, stop tracking, delete all resolved comments, and you're ready for signature. Okay, my laptop is definitely lagging, but you're ready to sign your document. So very important to know these features on MS Word. I keep posting about this on LinkedIn. In any case, you should watch videos on YouTube and try to explore a little bit of this platform also, because MS Word is something that you will use day in and day out, wherever you are, law firm, in-house, wherever you are, you will be using MS Word every single day. So going back to our presentation, just a second. Then, of course, we've got email exchanges. Now, once you are done with your side of review, you just like Preksha emailed the copy to me, I will also email mine to her after my review. Now, what we usually do is, hi Preksha, please find attached the reviewed draft for your perusal. At some point, I might want to get on a call also, because if there's too much redlining that has happened or we disagree on a lot of points, I might just want to, talk to Preksha on the call once and be like, listen, what is happening? What do you want? What can I give you? What can you give me? Let's sort it out. A lot of times, you know how we say that some things you should say in person or on the phone and not on text. That's because sometimes when you write things on um comments in MS Word or emails, they might not go in the same context, because Preksha doesn't know if I'm angry when I'm writing the email. Maybe I was angry and she thought I was just like very happy, or it was the other way around. So a lot of times when in the second review itself, there's too much redlining that's happened, I would be like, hey Preksha, I've reviewed the draft, here it is. However, let's just get on a call to quickly close this because there seem to be too many disagreements right now. Okay. And that is also not a simple thing to do, because maybe Preksha and I are both from our legal teams, but our organizations are very strict that the client facing person or the service provider facing person has to be from the commercial team. Then what happens is Preksha goes to her team, I go to mine, and they talk to each other on email, which is even more deadly, because if two commercial people are talking to each other about agreements, it may not end well. May not. A lot of times, a lot of commercial people are really good with agreements, but there's merit in asking for a call and getting that out of the way. Now, just for redlining and email exchanges and suggesting a call, I have a book recommendation, which is here. This book is very good. You can follow her on LinkedIn. Also, she keeps posting snippets of the book or tips and tricks on how you can redline, what kind of comments you should write for anything that you redline, when you do not need to write comments, etc., etc. However, whatever you read anywhere, take it always with a pinch of salt. Something that is relevant to her may not be relevant to me, because we are in two different countries, two different industries, and it could be the same with Preksha also, and a lot of you people also, that it may just not be the same. Everything is not going to be different, but not everything will work out for all of us. So if I share 200 tips with you, maybe 150, 170 will work for you, the rest may not. So that's how you should take them, and that's how you should try to practice or not practice them. On the same lines, now I've asked Preksha for a call. Now, how do I prepare myself? How does Preksha prepare herself? We go to our respective commercial teams or whoever the internal stakeholders are. Okay. And always, if of course this is something that I have been doing day in and day out, media agreements, then I will know what kind of deal terms generally there are. But I will obviously ask my team, hey, so is there an exception for this? Are we doing something differently over here? Oh, suddenly we are using A. Yeah. So we have to have those conversations internally, try to understand what the proper deal terms are, because if there is a disagreement on something, especially commercial, between Preksha and me, chances are she knows a different version of the same story than I do. So it's very, very important to sit down with your commercial team or any internal stakeholders that know the entire story to understand what's happening or what's going to happen, what's expected of both parties, and then go into the call with the mindset that you want to solve these problems and not fight with Preksha, because she is also a learned person and she's also trying to save her company from whatever liabilities could be there. That is the first point. Second point, talking with internal team, understanding what the terms are. Third is, which is also connected to the first one, you should always have fallback options. If you know that there is wiggle room in some clauses, try to talk to them. Like, for example, in our situation, we give 2 feedback rounds at each stage. Like if we are going on shoot, after that, there are 2, 3, 4 steps after that till we finally deliver. Every round, clients get 2 rounds. Now, of feedback. Now, if the client says nahi, on the first round, because it's going to be the crucial one, I need 4 rounds. if we've already had that conversation, if Preksha has already said that to me or I've said that to her, then we need to talk to our internal teams and say, hey, so what is the maximum that we can do? Because everything can't be a no. Because at the end of the day, you want to do business. And that's why we need fallback options. A lot of times I have gone into calls with fallback option A, B, and C. And then after that, if I'm still being pushed to give more or accept more, then we park the point and we say, okay, we'll just discuss this internally. And that brings me to the next point, which is an approval matrix. Having approval matrix for everything or matrices for multiple situations or limits or levels is very helpful. Now, if my client does not, okay, I'm the client here. So if I don't want to pay Preksha in 30 days, I want to pay her in 45 days. She will have to ask her finance team if 45 days are okay or not. What about cash flows? Will we be able to make that film or not if we don't get that money on time, etc., etc. Now, if she's pushing for 15 days of payment, I will have to ask my team, are we in a situation to be able to pay somebody within 15 days? There could be multiple reasons that I would want to increase the duration of the credit period. So Preksha sends me an invoice on the 1st of this month, and I probably want to take 30 days because I think that I have other expenses that are more important, or my teams are slow, or my processes are long. A lot of bigger companies have too many processes, which is for their checks and balances, which is great. But a lot of times what happens is that delays the processes. So understanding why we have a timeline for anything and what is the best we can do. And then, of course, if you have to go beyond the best, then you need to have an approval matrix where you go to your CFO and you are like, hey, so this is what this client is saying or the service provider is saying. And they're also saying that we don't want to work if you can't do this. This is a non-negotiable. Then you try to understand if the CFO says yes or no and move ahead. Business head, legal head, again, if you may have read about indemnity, limitation of liability, creative calls. So in this case, if I am the client and Preksha is my service provider and she's making my film, I will say I have the creative a final creative call. But if anything goes wrong, Preksha takes responsibility. Now, she might not be happy with that because if I'm saying yes and no to everything, then she'll be like, then what am I doing? I mean, why am I taking responsibility, But again, there are certain things that I can, ask her to be responsible for and vice versa. And that is the kind of thing that your legal head or your business head will give you an approval on. The final part of negotiation after your review, approvals, and meetings and everything would be stamp duty. A lot of times when people sign things electronically, they do not pay stamp duty. Sometimes they do. Whatever the case is, you need to understand if you are paying stamp duty or not, who is paying, which party is paying it, are you guys sharing it, how is it being paid? So there are multiple ways of doing it. Also, there could be a stamp paper which you'll go get at the court. In some states, so it's not available in Maharashtra, but in a lot of other states, you can actually get an electronic stamp paper also, which is different from e-stamp. So let's not get confused there. So another way of doing it is e-stamping. Then franking used to be done at some point. I think now a lot of people have stopped doing it, but there are a lot of ways of getting this also done. Which provision? So basically you've got your Central Stamp Act, you've got your state stamp act for every state, and then you have to determine which section is relevant, what kind of services are we talking about, or what is the subject matter of the agreement. And accordingly, of course, there will be a percentage of the value or there will be an amount given, and then that is how you pay your stamp duty. So these are the things that you have to, this is why this is a negotiation stages, because this is where you have to finalize it. Before finalizing all of this, do not go ahead, because at execution stage, if you were assuming there's no stamp duty to be paid, and if we've gotten the final approval, we just sign it today and tomorrow we're going to raise the invoice or tomorrow the work starts, it may not happen. Getting the stamp paper may take an extra day. Signing it physically, couriering it to the other side, or sending somebody to deliver it, getting their signature, getting it back, it may take longer than a simple electronic or a digital signature. So always keep all of this in the negotiation stage only and get clarity on every single thing before you actually go for signing. So this is the end of stage 2. Any questions wherever you think I have gone fast? I'm okay to repeat it. Let me know. Okay. Going 1, going 2, going 3. All right. Great. I'm either doing a very good job or I'm doing the totally opposite of it. I hope it's not the latter. Okay, stage 3 is execution. Here we basically, again, it really depends on the kind of company that you are working with or the kind of client or service provider that you're signing an agreement with or whoever the other side is. You need to understand in your organization who all your signatories can be. How have they been made signatories? If you are a partnership firm, for example, you will have to make a power of attorney just by virtue of being a partner while it is legally okay. A lot of people do not agree to it. They really need a POA for this sort of a situation. It's the same with companies. If you're a company, just because you're a director does not mean the other party will take it. You have to probably make a board resolution, give every single person the authority to sign business papers or whatever the subject matter of the document is. So, for example, your CFO may only have the authority to sign finance related documents. Your business heads may have the limited authority of signing only the main business related things. Now, if you've got a CEO, CO, they might have broader signing authority. They could probably sign everything that comes your way. This could be a letter to the GST council. It could be a letter to your your landlord for the office. It could be anybody, right? So you need to understand who your signatories are, who the other party's signatories are. If your organization wants these documents, board resolution or power of attorney, to ensure that the other person is a signatory, a valid one. In any case, you do ask for these kind of reps and warranties in agreements. So for me, it doesn't really matter. But a lot of people, just to avoid any problems in future, ask for these documents, and there's nothing wrong with this. You should, if somebody is asking you for these, just provide these documents to them. And always, as a lawyer of your company or firm, wherever you are, you should be ready with these kind of documents. Very important. As a lawyer, you cannot not have access to board resolutions, power of attorneys, or any compliance related documents. So whenever you join somewhere, know who can sign, in what capacity they can sign, and who has given them the authority to do it. Then execution mode, you can sign in a few ways. One, as we know, is physically signing it, where I'll probably take my most expensive pen and sign it in a good handwriting, or at least I'll try. Usually when you sign something physically, you will see a stamp paper affixed. Apart from this, you've got your DocuSign and Adobe Sign and all of these. These are all e-signing platforms. I've also said here digital, which is encrypted, mode of signing. Can anyone help me with the difference between electronic signature and digital signature? You can try, you don't have to be correct. No one?
Ma'am, electronic signature is a broader term or umbrella term, I would say, while digital is a specific one in which we use cryptographic technology to add more authenticity or security. And even in legal terms, we can say electronic signature is governed by IT Act 2000. But I'm not sure the digital signature, but yeah, it also mentions about the digital signature.
It does. So you're right, Satish. You have absolutely pinpointed what the exact difference is. Electronic signatures are broader. Somebody, I think, in the chat has also said something along the lines of it being, just a second, let me, it can be simply signed. Okay, so, sorry, scanned. Yes, you can, it can be a scanned signature. It could be just your Adobe or DocuSign signature also. And it does, a lot of times they do have timestamp, date stamp, all of those things. However, yes, digital signature is the one that's encrypted. The best part about these kind of signatures is that, so for example, if I have affixed a digital signature on a PDF and now I've emailed it to Preksha. Now, if Preksha wants to do some changes to the PDF, as soon as she converts the PDF to Word to make any changes, the DSC, the digital signature, will vanish. So that's the power of encryption over here, because you will not be able to, as we have someone in the chat also saying that for encryption, there's verification of authenticity, and you are also able to prevent tampering. So that is why a lot of people prefer digital signatures, because it's, you can't basically play with it, and it's just done. Also, if you're using a digital signature and then you're taking a printout, people do that, but it's not, then the purpose of encryption really just goes away. So if you've digitally signed something, definitely keep a copy of it on your electronic drive. You want to print and do whatever else with it, great, but you should have the original digitally signed copy also. Same with physical, which brings me to the counterparts point. Counterparts basically means, now Preksha and me, we are working together. Now I am this legacy client. I make teacups. We are 100 years old, so our processes are also old. So I say, listen, Preksha, I want to get this done fast, but I also want to do it correctly. So you arrange a stamp paper, or I will arrange a stamp paper. I'll print the agreement on it, get my signatories to sign every page, and affix our company seal also. Then I will send it to you, and then you sign every page and put your company seal also. Now, because it's been physically signed, how many copies would you keep, and who keeps the original? Unless you make two originals. When you make two originals, basically both will have a stamp paper. If Preksha is okay to keep an electronic copy only, she can countersign the document, keep scanned copy with her, send back the original, and then I keep the original with me. So that is also something that you need to clarify while executing, or during the agreement review, actually, where there is a counterpart section in the agreement. Try to understand if you're going to, how you're going to sign it, but it's not going to affect the agreement in any way. So you don't really have to, it's not an important point that you have to discuss during the negotiation stage, right? So yes, that brings me to the end of stage 3, which is execution. Would you like me to explain something? Do you want me to go back to a different slide, a previous slide, or should we keep moving? Thumbs up if all's good. Okay, great. Okay, moving on to the next stage, which is the final stage for your manual management of contracts. Storage and archival, which, as our flyer says, is where the process of contract management starts. I'll do that. I'll let me finish this and I'll go back to the first topic, Sonali. Thank you. Okay. So storage and archival, very simple. You just need to have everything in one place. That is all. How you have your clothes in a closet, but in different drawers or in different shelves, everything shouldn't be ideally together. As your parents would say that, okay, keep your shirts separately, trousers separately. That's how it has to be. However, if it is a core set and you have to always wear it together, which basically means that the agreements are related. So if there's a services agreement and then there is an addendum, or there is an SOW to that services agreement, You need to then keep them in the same folder, or you need to have them in a place where you can look for it easily. And it's not like there's one agreement in some other folder and the other one, which is related to this one, is in a separate folder altogether. This is how I have been storing all our agreements. So we have a client folder. Within that, because we do multiple projects with the same client, we do project one. So maybe teacup company. So teacup company would be the main folder. Within that, there will be teacup company Holi, and then teacup company monsoon, teacup company Diwali, teacup company New Year's. Okay, those are the projects that Preksha is doing with me. So this is how she or I both, and I both will probably save our documents. Now within the project name in Holy project, all my relevant documents that pertain to this specific deal will be saved in that specific shelf of the closet or in that specific folder. Why? Because again, easy to access. It's easier to have names in a good way because you will be able to search, which means you should know where exactly the agreements are. So Google Drive or your local shared drive, wherever you keep your information or wherever you keep your documents, one, you should have access to it. Two, there should be a pattern of saving, like how I have mentioned in the first bullet. And third is the parent-child document, which is all the related documents. They should be together as much as possible. Wherever you save your documents, I'm sure you will have a search bar. So you should also have a good file naming system. Now, why I have in my first bullet written that number, can someone tell me what this number denotes? Can someone take a guess?
It's the date format, year, month, or date or year, date and month.
Yeah, so why have I written it in YYMMDD format?
Because then the folder name in the files would come in a chronological order of the years. Like all 2025 files would be first, then 24 if we arrange them by the descending order.
Perfect. So this is how I have been saving my documents for the longest time, because this helps. It just, the look of it, you know what the effective date is or what the execution date is, and then you know what the subject matter of the agreement is and what the parties' names are. I also have a habit of doing a hyphen, especially in NDAs and stuff, to ensure that when I look at the title, I know how long this is valid for. So if I put a date and then I put 3 years, then of course it will make sense. The issue with all of these storage places is that on your local file explorer also, or on your Google Drive and all also, if you change the name of a document also, or if you copy paste it somewhere else, the modified date will change. So don't go by that. Open the document, try to understand when it was signed, when it was effective from, and name your documents in a way that you know that they'll be easier for you to find them. So another example of using numbers could be, in our organization, we give a number to each project that we do. And of course, a lot of people have their client codes also, or their vendor codes also. So if I know for a fact that my finance team wants to keep looking for agreements because audits keep happening, they want to access agreements, so on and so forth, then I can maybe change the number from this year, month, date naming system to the client code or to the project code. In most probability, that will also be dependent on, that will also be in an ascending or a descending order only, because when any kind of numbers are given to any projects or clients, they are usually chronological in order, right? So choose what is best for your organization or what is best for your team. You should always understand that it's not that I like how it looks. It should be like, okay, if I write this, will it be searchable later? So 2 years down the line, if somebody wants to look for something, should I then change the name according to that? So a lot of times I also, if I know for a fact that we work with the same company for multiple projects, I also put the project name in brackets, like Holy Diwali, whatever the project name would be. And that's how I save it, so that I can just search it with the client name and the project name, and it will appear in front of me. So that's how you are supposed to store your documents for easy access. This is where a lot of hard work goes, where you do not have an automatic system or an automated platform. So metadata is basically all the important information that comes out of your agreement. Anything that you've signed, obviously it will have a start date, it will have an end date, it will have a notice period for termination, like, okay, you can give 10 days notice or 30 days notice to the other party and terminate the agreement if you want to. There could be so if Preksha is making something for me, she might want to on her website tell people that she's made a video for my brand. So maybe she wants to use my logo, the teacup company, and she takes permission for that. So all of those kind of things, whoever is finally getting the agreement signed within the team, they would want to compile all of this data and put it in an Excel sheet or in some common place where it's easier to access. Very honestly, whenever we have maintained this, I still, to double check, go to the agreement and read it again, just in case we are missing any context. But it's easy for us to have details like start date, if execution date or expiration date, term, whatever, all of these kind of things, because then this sort of helps us understand what our next steps could be. Along with this, there would be other details like how many deliverables there are and stuff like that. Of course, that could be a long list, so you don't have to write everything. But something that, again, this is also from a POV of, if I want to, or somebody else in the organization wants to look for something, or they want to search something, what would they search? So logo usage is something that's very common in our industry, which is why whenever we have taken any kind of rights or given somebody the rights to use our logo, we always mention in the metadata that, okay, this person has been given the right to use our logo with or without permission. Okay, so that is something that you have to, within your organization, understand who will need what kind of information. That's how you extract your metadata. By extraction, I just mean open it, read it, make columns in your Excel and fill out the information. The last part is reminders. Why I'm clubbing everything within the bucket of reminders is because now that it's done, your agreement is signed, you'll probably forget about things. And also it's humanly impossible to remember all details of any kind of deal unless you're like day in and day out working on it. So there is definitely, after you've signed an agreement, there is need of understanding when deliveries are being made, what are the next steps, if there is a warranty, how long is it for, so that within that warranty period, if you have any issues, you can go back to the other party and be like, hey, so I need help with this, and because we're still under warranty, these are the terms. Payments. So for example, if I were to pay Preksha 50% in advance right upon signing the agreement, then the moment I sign the agreement, she should be able to raise her invoice and I should be able to pay her like the same day or the next day. That's something that will happen after signing, but it has to be taken into account when it comes to keeping reminders on your calendar or asking your commercial team to follow up from the other with the other team, and all of those kind of obligations that happen after signature. Then there could be, now of course advance is still something that you can track because you know it's going to happen before you start a project. But if there's something that's being paid to you monthly, or it's something that you are paid after you have delivered something and the other party has accepted the delivery, and then only will they pay you, that's again something that you have to note down, or you have to talk to your team about and ensure that those payments are coming in on time, or those deliveries have been made on time. If you want to renew your agreement, very, very important. A lot of companies globally have lost deals or money because they have forgotten to renew their agreements. Because, just like your insurance person or whoever you have your yearly thing with, they know that something is expiring in your, you know, like in your whatever policy you have, whether it's insurance or it's something else, some other subscription, people know that. So they will reach out to you, they will keep pitching to you. And if I'm not proactive in renewing my agreement, I might end up losing that deal. So very important to have a 90-day to expiration reminder sort of a situation where you get those reminders, and then you go back to your commercial teams, try to understand if we need to renew the agreement or not. Is this something that we'll be doing again? Do we want to work with them? If yes, then should we start the conversation? Who starts this conversation? When do you want to conclude the conversation? Do you want to sign the same thing, or do you want to renegotiate any terms? Because if it's a year on year agreement, you might want to change certain terms also, which is why it's called life cycle. Because a simple renewal can just be, like, okay, an addendum saying that, okay, fine, we are extending this agreement for another year or whatever. You can do all of that. However, a lot of times deal terms are renegotiated, which also impacts the legal side of things, which means you will go back to stage one, which is creation. So all of that has to be monitored by the legal team, of course, and of course the other internal stakeholders as well. And that is how your manual contract life cycle management goes on, doesn't come to an end unless you're terminating an agreement or not renewing it. But this is what happens. Somebody wanted me to repeat the first topic in short. I will go back to it just now. Does anybody have any other questions? Thumbs up if all good. Yeah. Please unmute yourself and ask your question. Deepika? Hi, Deepika. Do you have a question? Are you able to unmute yourself? Okay. Preksha, can we please unmute Deepika because she has a question?
Yes. Deepika, I think you should be able to unmute because everybody else is able to. I've not enabled any host management of any sorts. It's probably something from your end itself.
Are you not able to see the audio button? Is that it? Okay. Why don't you try rejoining the meeting, but join it with, or you can just put your question in the chat. Yeah, let's do that. I'll go to the stage that we were discussing. Yes, MS Word and PDF are actually not automated. So for those of you who are not looking at the in-call messages, Deepika is asking if there are other kind of automated softwares in the market. Basically anything apart from MS Word and PDF. So yes, the next session is about automated softwares only. I will give you a few examples. I will also help you understand the kind of or the level of automation that you can get to, and how it can save time and how it can make you more efficient, and your life is easier after that. So I will discuss, but yes, definitely there are multiple CLM platforms today, from your contract book to spot draft to panda docs to hyperstart, and there's a lot of them. Some are AI powered, some are not, some do the creation thing in a different way. But yes, I will be discussing all of that in the next section. Tab tak we'll go back to the first stage, as I think Saloni wanted a quick revision. Okay, so going back to stage one, now let's assume that we have worked for 1 year together. Yes, Deepika, we'll talk about that also. Now, Preksha and I have closed that agreement. 1 year has passed. We now want to renew. Okay. So we come back to stage one. So Saloni, for you, stage one is where we are basically creating things. A lot of times you do not just auto renew an agreement by signing one piece of paper. You want to renegotiate documents. Also, in a span of 1 year, or how many ever years it was that agreement was for, there could be changes in laws, there could be change in management, there could be changes in your organization's policies, there could be changes in your offerings, your payment policy. A lot of things can change, which means when I was speaking about this, I said the first thing that you need to have as the legal team, wherever you are, be it in a legal, like a law firm or a different industry and in a company, in-house setup, you need to have agreement templates. So whatever you deal with regularly, you need to have templates for that. If there's something that you have dealt with more than twice, definitely make a template for it. So maybe once Preksha and I have signed that agreement and our deal is over, we want to renew it. But because I'm a legacy client, I am 100 years old, I have made some changes in the template because suddenly some management change has happened and they're like, no, we want different language in this kind of clause or whatever. So now there's an agreement template that I have, which is different from the previous one. What I will do is back to square one, right? So I take that agreement template, I am ready with that document. And now the second step is to get information. I go to my commercial team. I try to understand from them how Preksha's company and our company are going to deal with each other. And the way we can get this information depends on the kind of work that you all do or the complexity of the deal. So a lot of times I have used Google Forms. We have also had estimates or project related documents that not only give a cost breakup, but they also give other details of the deal. So for example, your timeline, when what is going to happen, the kind of deliveries that will be done, if there is any support after delivery, what kind of support is provided, what kind of support is free, what is not, stuff like that. Okay. So again, depending on the complexity of the deal, you can either sit down with your team and have an understanding of what's going to happen, write it down in your notepad, or make notes on your MS Teams or Slack or wherever you chat and share it, get it confirmed, and then you put all of that into your template. Or if you have a standard process and your deals are, however complex they are fairly standardized, or they are not very complex, you can just do like a simple form, a Google form. You can be like, okay, start date, end date, what are you offering, what are they giving you, etc., like your 8-9 questions, and you can get all the details, put all of that in your agreement template, understand if any of these commercial terms change your legal terms also. And if they do, try to understand from the commercial team or the business heads if that is a change that you want to make, or do you want to change something in the commercial understanding, which is highly unlikely, but you can and you should always ask that question. The third part of the creation stage is understanding what the accepted formats are. Now, I only wrote this because while I am an MS Word fan, I also work on Google Docs because sometimes our clients are like, hum to Google Docs pe hi kaam karte hain, which means I cannot say I don't like Google Docs. I only want to work on MS Words. If they say that they want to work on Google Docs, I will have to say, yes, absolutely. That's my second favorite platform. So I will work on it. And that's what we do, which means whatever your accepted formats today are, except I think PDF. I think nobody likes PDF because it's just a passive aggressive way of saying that I'm not going to entertain any negotiations or changes. But MS Word, do you want to keep it open or locked? Google Doc, do you want to give the other party comment access or edit access? And stuff like that has to be figured out. What kind of document do you want to use finally and send out, and how? On email, or do you want to send them a link? How do you want to do it? So that has to happen. Okay, one thing that I missed while I was discussing this was there is Google Drive for desktop that you can download if you're somebody that works on Google Docs and Sheets. What that enables you to do is there's a doc word compatibility and Excel and Sheets compatibility. So if I have something on my local drive, File Explorer, if I connected it with my Google Drive, I will be able to open it on my desktop directly on MS Word, make changes, close it. I will also be able to open it through my Google Drive on my web browser, and it will open as a Google Doc. Now, how that helps me is that if Preksha is from another company, or if I have other colleagues that want to collaborate with me on this document, because I love MS Word, I will do everything on MS Word. But when I want the others to collaborate, or when I want Preksha to give her inputs, what I'll do is I will then open Google Docs, send them this link, give them comment access. They will be able to comment. They will also be able to make changes, but those changes will be done in color. So I will be able to see those changes. So that compatibility is really a boon for us today, because again, people are moving from desktops to like online platforms like, again, Google Docs. So it helps because if you're still stuck with your offline versions, you can always still work with both. So you have your comfort of MS Word, and at the same time, you're able to fulfill the other party's need of being able to do online or collaborating real time and all of those kind of things. So that's what we had discussed in this stage. All clear? Am I doing justice to this topic? Anybody, any questions? Okay. Perfect. It's time to then move on to the automatic this thing. So the automated way of doing contract lifecycle management, which is basically having a CLM platform in your organization. Now to answer your question, Deepika, AI taking over drafting jobs. Sure, they might not take our jobs. I think if a legal team has 5 people, maybe 1 or 2 people may lose their jobs because we will not need as many people to draft anything. But I am also of the opinion that there's not so much drafting needed in-house, because a lot of times you're just doing template drafts. Of course, changing things along you go, but it's not going to take away your job. One good thing to know is that all of these things, like any kind of technology, any kind of disruption, is not here to take your job. It's here to make your life easier. It may be a very delusional thought, at least maybe 10 years down the line, 20 years down the line, I don't know, maybe it has taken away my job. But what I'm trying to say today is that if you know, when probably you were not even born, I was not even born, people used to go to libraries and courts and look for like older case papers. There was no Manupatra or SEC online, so all of that was eventually digitized, right? Everything became electronic. In our industry, our CEO recently gave us this example when we were all crying over AI, and he said, earlier editing used to happen like this, that we have shot something, we have a reel. Now people used to cut it manually, shot by shot, and paste it together. And I don't know if I'm doing justice to this example or not, but this is how editing used to happen. And then eventually editing softwares came into the market. People who did not want to use those softwares, they stayed there, they became redundant and obscure, and then nobody really went to them for any editing. But people who adapted to the technological disruptions, they were the ones who were able to keep their jobs or get better at their jobs. So that's what we are doing. So like you also said, yes, we use online Manupatra. That is the point. I mean, you don't have to walk to a library close to your house or office, look for documents, look for commentaries. You can just go online and look for anything, right? Now, has that taken jobs of interns? Because that's what interns used to do earlier. No, it hasn't. So what we need to do is just adjust to the technology and also adapt well, like learn what the technology can do with us. So like how in the second section, the negotiation section, when I opened the MS Word document and I said, you need to know what each function does. If you don't know MS Word, I will take your job because I know I'm very good at MS Word, right? So you need to, whatever you're using, you just need to know how it can be used better. Are there any other features? Like AI also today, of course, you can use Claude AI and ChatGPT and you can make the first draft. However, there will be so many details that you'll have to feed to that AI also. So you may have to tell them, okay, I am a media lawyer working for this company. These are my company details, blah, 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 blah. And this is the kind of work that I'm doing with this client. So there's a lot of details that you have to feed into that AI software also for them to get you the first draft. And if you have a rough first draft also, you still need to put in your brain and understand if this is even making sense or not. Right? Also, just flagging before we move to the next section, a lot of countries like the US, they have started noticing that lawyers or advocates are presenting fake case laws like how we used to write in our exams. And those case laws just don't exist because people are using AI and they're not verifying those things. So very important to note, jab tak AI is not accurate, you will anyway have your job. It's just that you can still use it to help your, help save your time or make it more, basically whatever you're doing, it will become more efficient. That is about it. Okay. But also, while these platforms can draft things for you, do not stop practicing. Keep drafting, keep reading, rereading contracts. At any given time, it shouldn't be that you don't know what to write in a force majeure clause just because you know ChatGPT can give it to you. No, you should know what to write. You should know pandemics are now included in all of this. So you should practice. And of course, if eventually they take our jobs, fine, we'll figure something else out. We're lawyers, we're smart. Okay, coming to the automated version of the same thing that I discussed earlier. Now, here I will discuss what all you can do on a CLM platform. This slide is an overview. Just only calls and meetings cannot be done on the platform, and obviously physical execution can't be done on this platform. Rest, everything can be done on the platform itself. This is how far along our technology has come in the legal world. Okay. Now, for contract creation, there are multiple ways again to get information. Our ideal scenario here is that all of our organizational people are on the platform. They are all paid members or however it goes, but everybody is on the same central platform and they can all collaborate. Okay. Now, there has to be a contract creation, which means there will be a request sent or there will be a form that somebody will have to fill. So assuming everybody is on the platform, my commercial counterpart will open a link within the software, which will come up with a form and it will ask them these kind of questions. Now the questions would be start date, end date, any other important information, deliverables, rights, limitation of liability, whatever. It's a legal point, but all these important kind of things in the form itself. Now, a lot of templates within these CLM platforms have placeholders, and their forms and agreements like templates are trained in such a way that whatever I write in a specific field of the form, it will translate into that corresponding field in the template also. which means if I have written the start date somewhere in the agreement, wherever it says from this date, bracket effective date, that is where the start date will be reflected. Okay, so of course, you have to spend some time and effort into setting up the system, but once it's set up, it's very easy. So now the best thing here was that somebody else has filled the form, so the accountability is not on you. Automatically the information will go and be fed into a template, and in the corresponding fields where you are supposed to have that information, you will get that information, right? Review and redlining. Again, ideal scenario is that this is the best CLM platform out there. Our company has done a lot of kharcha on us, on the legal team. So we have the best solution, which means AI powered comparison. So again, if Preksha has made the first draft and she has sent it to us, when I load it on the CLM platform, or if it's already loaded, assuming she's also on the same CLM platform, if I run AI on it, AI will be able to compare and tell me how how much of a deviation there is between Preksha's agreement and my template. So then what happens is, of course, anyway, I will read the entire thing, but AI has just made it simpler for me to specifically know where I have to give more attention, which means if the deviation somewhere is much more, like if she wanted to get paid in 10 days, but I can't pay her before 15 days, then that is a significant deviation. I will go there, I will redline it, I will make a comment and stuff like that. If she has asked for unlimited liability and I don't want to give her unlimited this thing, indemnity, I will cap it at some point, and that will also be significant deviation because I want to keep capped liabilities only, and she's asked for uncapped. So there also, from 0 to 100, we will know that, oh my God, this is a big difference. So that is also something that a CLM platform can do. The AI powered ones can definitely do it. So that is what the platforms today are capable of. A lot of times they have MS Word or some other similar kind of platform natively on their system only, or on their platform only. So that means if you open the contract, either it will give you a pop-up of MS Word and the MS Word document will open, and when you're done with your changes, you close it and it goes back to the platform as a new version. Or within the platform itself, it will have a MS Word sort of an application where you can make changes, and it has similar features. Another good thing about these kind of platforms is that if I need people to collaborate, or if I need approvals, then I can directly tag people within the platform. So I can be like, hey, Preksha, please help me with this, or at CFO, please confirm if we are okay to do this, So all of that can happen within the platform. Again, ideal scenario is that there are CLMs that do this, where internal comments and external comments are marked separately. And if by mistake I have just sent the draft without cleaning it, the other side will not be able to see the internal comments. So that is also a very good feature of any kind of CLM, that, okay, we are not checking everything thoroughly. And even if we are, sometimes we do end up missing such things. So at least you know that internal comments are not going out anywhere. Approvals can be taken, email exchanges can also happen. So there are features where you can get a tracking link, or you can within the platform only just send an email and it will come to your inbox. But it's happening through, so you basically don't have to leave your platform. It can just do everything for you. Storage also, signatures also, everything is done there. Metadata extraction, the most difficult part of all. Now, if you have created the contract from this platform itself, great, because that form that you filled, it already has your details. However, if before getting the CLM on board, you had signed a lot of agreements and you need those details with you, again, a simple AI run or any other kind of software that they have that is able to get metadata out of these agreements, that will just give you all the important legal pointers. So for example, again, start date, end date, notice for termination, what is the term, what happens when there's a breach, force majeure, logo usage, all of those kind of things. And also reminders for renewals or anything else that you want. So these reminders are also, you get your 90 days, 60 days, 30 days, 15 days reminders. You can also remove them, abandon them, stuff like all of that can happen on these CLM platforms, AI powered or otherwise. Now, the uh, kind of platforms that people generally use would be, because like I said, not everybody in all organizations would want to adapt to a new platform or get onto a new platform. What we generally do is we just take the information, fill the form on our own, and then we use our, of course, normal email to send and receive the document, MS Word to redline our drafts, and we close it. Then we finally use the CLM again for electronic signatures. We store it within the platform because they have given us storage. And metadata extraction and reminders finally help us with the completion or the renewal of the life cycle. And we don't really have to set up anything. Like if I have already uploaded an agreement or I signed something to the platform and we know that the agreement is expiring in 1 year, I just sign it and keep it. I don't even have to change its name. I don't even have to, have it in some folders. It's just in a repository, and I just search for the name and it pops up. And whatever information I want, it's right there. And whenever the reminders have to come, there could be like um, a basic protocol within the platform that, okay, every month I need a 90-day reminder, or for every agreement I need 90-day, 60-day, 30-day reminder of sorts, and you're done. There is all of this manual work that you would do otherwise, that is all gone. And then of course, what is done outside the platform, it's still happening outside only. One day we'll probably have it all together. And yes, the last part of this entire webinar, this presentation, is that when you have a CLM platform, you are also able to focus on the numbers. Now, this will help you understand if you have a fast team or not, what kind of agreements are getting stuck, what kind of clauses are getting stuck, stuff like that. So like all of these things that I have written here, this is the kind of information that I think is important. So for example, how many times did we sign our agreement? How many times was the other party's agreement accepted? Who took how much time at which stage? And how much did we deviate from our standard template? And project value, liability caps. All of these are important, because then if we are deviating too much from our template, then might as well just change our template. So this is the kind of information that helps us actually in the long run also. But again, for a smaller company or a company that does not have to think too much about all of these things, this may not be a very good investment. But these are the kind of features that we have on our CRM platforms that exist today. And they are all pretty good. Just compare, contrast, see which one works for you best, how much they cost. Is your company going to, like, are your colleagues going to be a part of it or not? And that's about it. I'm done with all of my legal jargon for today. If you have any questions, please let me know. If you have any feedback, please fill the form. Be gentle with the feedback. Give constructive feedback only. And yeah, I'm here for any questions. And connect with me on LinkedIn if you want to know more about anything at all that we discussed. I really am sure that I am pretty good with MS Word. So if you need any kind of MS Word tips and tricks, I can give you those also. We can do a crash course of sorts, get together and do it together. But yeah, I hope you found it a little bit interesting. You found it insightful and it was helpful. And if you need any more clarity on any kind of points, please let me know, and I'll help you out. So we'll be giving you the slide. Preksha, will the slides go to them? So the last slide of the presentation has my LinkedIn link also, and our company's website also. Please give them both a visit. And if you have any questions, anything at all, please let me know. And I am pretty responsive on LinkedIn, so I'm not going to ghost you. Thank you. Cool, Preksha. If there are no questions, I'm happy to let people go early because we have work tomorrow.
Guys, does anybody have any question before we wind up? Okay. If not, you can send your questions to me. I'll be forwarding them to ma'am and she will be answering it later on. Okay, right. So I don't think, ma'am, there are any questions.
Ma'am, good evening. Sorry to interrupt. Am I audible?
Pancha, yes. Yes, it's a little muffled, but I can try and understand. Please go on.
So my question, first of all, I would like to thank you for giving such a excellent session. It was very worthy, like you have explained in such a great manner. My question is basically that while if we are working in corporate sector, like while we are working in a corporate sector or we are drafting a contract, what should be the first and last thing we should focus on most? Like while drafting a contract, there are many things we should need to be focused, like either what the content we are drafting for. But according to you, which is the foremost thing we should need to focus on the contract while we are drafting for either a company, either a LLP, either ONS? That depends.
Okay. Um, I'm going to give you a very industry agnostic suggestion. I have believed for a very long time that if you know, my hashtag on LinkedIn is actually legal jargon, because we end up using a lot of legal jargon, which I am not. I do not condone that. So my only suggestion to any drafters would be, therefore, thereafter, ये सब words छोड़ दो. मतलब if you can use simpler words, please do that, because and I'll tell you where I'm coming from, because when I was with Universal before this and now I'm with Kulfi, we used to deal with artists back then, and we today also deal with a lot of artists, and they are not always represented by lawyers. So when you throw a lot of legal jargon at someone, they get scared and they don't want to work with you. So try to ensure that your language is simple. That said, know what your roots are saying. I mean, don't forget what the meaning of the word notwithstanding is, but you don't have to use it. So try to keep your language very simple. Okay, that is the one suggestion that I have with everybody, also, like for everybody. The second one is, I think people may sometimes end up saying that, okay, this is the right way of doing it, or that is the right way of doing it. And this is, I'm strictly saying from a style perspective. I believe that everyone has their own writing style. If you and I have worked on the same document, but I have made some changes to your language, but it does not significantly change the meaning, then my change is not needed. Okay. So while reviewing also, while drafting also, always ensure one, simple language. Second, don't make unnecessary changes or additions unless it's actually adding value. And keep it short. If something can be done in 5 pages, don't do it for 40 pages. That's it. That's about it. That's the best suggestion I got from my seniors, and this I'm passing on to you all also.
Thank you so much, ma'am. It was a good advice. And my last question is that should we use action verbs in a contract? Do you think, like when we are starting a line, particularly, we should start it with just I, we, or they, or should we start it with action verb?
Doesn't matter. Again, it's writing style. If you want to be Victorian in life, you can do that. I prefer to keep it very simple. and something that's not sounding like Elizabeth wrote it before she passed. So it's a style thing. It's not wrong, as long as if you're signing it with somebody, they should understand it. If there's a problem later on, the judge should understand it. It should not be contradictory. That's all. It should just be that ab kaise bhi shuru karo, kaise bhi khatam karo. It does not matter. Okay. I think no more questions.
There is a question on the chat box. Sam Sirion asks, what platforms would you recommend that we follow for agreement formats or templates in your capacity as an experienced professional?
I did not get the question. Do you mean that you want templates from somewhere, or do you want to save it in some way? Preksha, am I reading it wrong?
No, I think what they want to know is where they can get good agreement formats or templates from any website.
Got it. I have not usually looked at like a specific platform or something. It's usually whenever I needed something, I would just go online and check what people have been writing. Another thing that's helped me in the recent past is following the right people on LinkedIn. So good that you asked this question. I'm going to share a link here on the chat. I had subscribed to this person very recently, and yeah, if you go through this, you'll be able to get a lot of information about like books, blogs, LinkedIn thought leaders in general, podcasts that you can watch, etc. And you will be able to get a lot of templates across from a lot of these people. Like Contact Nerds is something that I've been following for a while now. This is the person whose book I also recommended because she is great with redlining techniques. And yes, this book is available on Amazon. I have a copy. You can, I think the right way to go about it is, of course, because you're just starting out, just go online and check what kind of drafts there are out there. Slowly, when you're starting to follow the right people on LinkedIn, they will end up giving you drafts. Like I don't remember his name, but there's this creator on LinkedIn who randomly just, in a month, he publishes 10 drafts about an industry. Like if they are doing software as a service, SaaS agreements, so they will have 10 examples of agreements that are used within that industry, and they will give it just for free. Now, of course, it may not fit your purpose. You may just have to download and see what is useful for you. But this is how I have been procuring. I'm sure, sorry, I don't have I don't have one source for all kind of documents, but this is the most helpful link that I have today. Anyone else? I'll just check the chat also. Which CRM platform is best for learning automated contract management? CRM platforms are usually not free, so you might have to maybe. I think demos are good. You should go to companies like Spoddraft and Volody and Hyperstart, Contract Book, which is I think it's a Dutch brand. They all are CLM platforms. They might give you good demos, and that's how you will understand how things happen. It's good to keep watching YouTube videos about these kind of things because things always keep changing also. So that would help. And yeah, I think in general, whenever I've had to do any kind of comparing, contrasting, I've just gone on these legal blogs where people do compare features of these CLMs. So I think that would be helpful. I don't think you'll be able to enroll or like subscribe to a CLM to understand what they do, because CLM comes with like a membership fee and stuff like that. So that may not work. Like to learn, you will have to actually get into the system, pay for it and stuff like that. So I think unless you know a free platform, I don't think there's another way to do it. Any other questions? I've gone way up in the chat. Yes, Rida.
Ma'am, actually, I would like to ask you when you started with in this department of contract lifecycle management. How was your journey initially? Like, where did you start from particularly?
So in my previous company, because it was an established MNC, they had their own rules. There was not much that I had to add, which is a great thing because I learned a lot. Um, that is when because it was an established company and team, there wasn't too much of experimentation that I could do. But anyway, I was there for a very short amount of time, so I learned as much as I could with respect to naming folders or naming agreements or what kind of metadata is important and stuff like that. So a lot of learning is what I did during that. Soon after, when I joined Kulfi, I was actually the first legal person. Like, I was the one where legal team started within Kulfi. So that was quite a journey because not everything was the way I would have wanted it to be, because again, it's a style thing. If I leave today, somebody else comes, they'll be like, oh my God, Shriya ne to kachra karke rakha hai. That's how everybody works. So that's when I started devising new processes and policies and stuff like that. And that is where a lot of more learning happened, because then I started going online, checking what these CLM platforms are doing, how are other people doing it. I got connected with other people within the field, peers in my industry, to understand who's doing what kind of things. So it was not just, okay, how do you negotiate this credit point within OTT? It was not limited to those kind of questions only. It was also about, okay, what do you use a different platform? How do you, like, keep track of renewals? So it was a huge learning experience. It was a little overwhelming because nobody teaches you these things in law school. Like, even the law that you learn is also not foolproof. Like, you come out learning that it's totally different in the practical world. But reading, watching videos, talking to people, very important. Like, keep reading as many agreements as possible. And I'm usually happy when somebody else sends their agreements to us, because it gives us a fresh perspective also. And we're like, oh, maybe we have missed this in our draft. Maybe, we can add this. A lot of good drafts are basically a combination of other people's good clauses. So it's like how our Indian constitution was also made. A lot of people say that. So it's just that. So knowing what you want will only happen when you know what all is out there. So read, watch, talk, do all of that. Yes, Shelly, please. That was my mistake. Okay, any more questions? Yes, please unmute yourself and share your question here.
Hi Shreya, I have been following you on LinkedIn for quite a bit, and I'm really glad to be here and learn so much about contract management and the whole life cycle process of it. I wanted to ask you how you chose the industry you're working in. Like, why did you choose to work where you're working in? Yeah, that's it.
No, it just happened. I didn't choose anything. I did my master's in IP. It was because I was interested in the science side of it, like patents and everything. But when copyright happened or media happened, I did not say no. It's definitely an interesting industry, and it. I always thought that if I found something boring or I found myself getting stagnated, I would want to change or improve things or whatever. But that's not happened till now. So again, to answer your question directly, I did not choose it. It chose me.
Thank you so much.
All right. I don't think there's any more questions. Shreya, if there are more questions, I will definitely forward them to you. So with that, we come to the end of today's session. Thank you so much, Shreya, for taking time out and actually coming today and taking this session. We've learned that contracts are not just legal documents, they are frameworks which need to be managed carefully across the entire life cycle, and obviously with the right systems in place, with the right mentors, and with the right mind frame, or with the right frame of mind, they can become powerful tools for both compliance and for growth. A big thank you to all the participants as well for joining us today. Please don't forget to fill the feedback form. We'll be sending out these certificates only to those who fill it out. On behalf of Legal Specs, thank you once again, Shreya, and we look forward to having you with us in our upcoming webinars as well. Thank you, everyone. Have a great evening. Shreya, I will connect with you in a few minutes.
Yes. Thank you so much, everyone. Have a great evening. Bye bye. Thanks, Preksha.
Thank you. I will see you soon. Guys, please make sure that you fill the feedback form before you leave. Only if you fill it out will you be receiving the certificates. And once you do fill it out, please start leaving. Thank you.